So good morning. Welcome to this Legal Aid New South Wales and LawAccess webinar. My name is Bridget Barker and I work in the Community Legal Education branch of Legal Aid New South Wales. Our speakers today are Michelle Tolmie from LawAccess New South Wales and Emma Zammit from the Early Intervention Unit of Legal Aid New South Wales. Good morning, everybody. To begin with, I want to acknowledge and pay our respects to the traditional owners and custodians on whose land we are broadcasting from today, and to extend that respect to any Aboriginal or Torres Strait Islander people joining the webinar today. So, what we will cover in this webinar today: parenting after separation, child support and Centrelink payments, separation, divorce, property and finances, addressing safety, getting help, helpful resources, and answering your questions. So now I'll hand over to Michelle and Emma.
Thank you, Bridget. So we'll start off with the divorce topic. So what is a divorce? A divorce is the legal end to a marriage other than by the death of one of the parties. In Australia, we have no-fault divorce. What this means is that when deciding whether to grant a divorce, the court does not consider why a marriage has ended or whether one of the parties was responsible for the breakdown of the relationship. The court must only be satisfied that the relationship has broken down irretrievably. That is, that the parties are not going to get back together. In Australia, divorce is an entirely distinct process to parenting and property proceedings. Parenting and property can be dealt with together, but divorce is entirely distinct. Divorce applications are heard by the Federal Circuit and Family Court of Australia. Next slide, please, Bridget. There we go. Okay, so when can a person apply for a divorce? A person can apply for a divorce if they are legally married. This includes overseas marriages that are legally recognised in the country in which the marriage took place. It does not include de facto relationships and Aboriginal customary marriages. A person can apply for a divorce if they have been separated from their spouse for at least 12 months. Their marriage has broken down irretrievably and there is no reasonable likelihood that they will reconcile with their spouse, and you prove this by being separated for at least 12 months. The person applying for a divorce or their spouse must be an Australian citizen. They must regard Australia as their home and intend to live in Australia indefinitely, or they must ordinarily live in Australia and they must have done so for 12 months immediately prior to applying for a divorce. If the parties have children under the age of 18, they must have made appropriate arrangements for the care of their children. This criteria is a little bit loose, but it is still a criteria that the parties must satisfy. If someone applies for a divorce, there are some other practical matters that they may also need to consider. They may need to change their name. They may have to update any superannuation or life insurance beneficiaries, and they may also have to update their will. Getting a divorce will revoke or cancel any provisions in a person's will that makes a gift to their spouse or appoints their spouse as executor, trustee, or guardian.
Okay, so the next topic we'll be looking at will be parenting after separation. So when parents separate, they often need to decide on what arrangements will be in place for their children. So this might include where their children will live, how much time their children will spend with each parent and other family members, such as grandparents, where the children will go to school, and who will have parental responsibility for their children. The law doesn't tell parents how to care for or to make the day-to-day decisions for their children. Every family is different and every child is different. So the arrangements that work for one family may not necessarily work for another family. Next slide. Thanks, Bridget. Thanks. So what does the law say about parenting? So the law says that all parenting arrangements should be made in the best interests of children. what is in the best interest of children is determined on a case-by-case basis according to the needs of that child. So the safety of every child is of primary concern, and children have a right to a meaningful relationship with both of their parents unless there are safety or risk issues. Parents have the responsibility of deciding what the arrangements will be for their children, and it's generally best if parents are able to talk about and reach an agreement on these arrangements. Great. Okay, so where parents can decide on the arrangements for their children, they don't need to go to mediation or apply for court orders. They can have an informal agreement, or they can enter into a parenting plan, which is a written agreement that's signed and dated by both of them. If parents want an agreement that is legally enforceable, they can apply for consent orders. However, in situations where parents can't reach an agreement, they must attempt family dispute resolution, which is also sometimes called mediation. And they must also take genuine steps to resolve their parenting dispute before they can apply to the court for parenting orders. In limited circumstances, parents may be exempt from mediation. Those sorts of circumstances include where the matter's urgent, there has been or there is a risk of child abuse, family violence to either a child or a parent. It can also include situations where a parent can't effectively participate in mediation. An example of that might be where one of the parents is in jail, the other parent may be overseas. It can also include where a parent has breached a parenting order that was made in the last 12 months, and that there's reasons to believe that the parent's shown a serious disregard for those obligations under that order. So if a parent was to think that they were exempt from mediation, it's something that they should speak with the mediation service about or to get legal advice on. Where parents can't decide on the arrangements for their children and they've attempted mediation and taken genuine steps to resolve their dispute, they can then apply to the Federal Circuit and Family Court of Australia for parenting orders. So parenting is different to care and protection, which involves the Department of Communities and Justice. So the role of DCJ is something that we'll address in a later webinar in this series. Other considerations with parenting can include child support and any Centrelink benefits. So what is child support? So child support is money paid by one parent to the other for the care of their children. So this is different to spousal maintenance, and again, this is something we're going to cover later on in this webinar. Both parents have a legal duty to provide financial support for their children, and that duty exists regardless of the type of relationships the parents were in, if they were in a relationship at all. It exists regardless of where their children live, and it also exists regardless of how much time a child spends with each parent, even if that's no time at all. In addition to child support, a parent may be eligible for Centrelink benefits, family tax benefits, as well as childcare fee assistance. Again, child support is a topic we'll be addressing in more detail in a later webinar within this series.
Okay, so next we will cover property and finance matters. So to take you through property, this might include real estate such as houses and investment properties, businesses, corporations, cars, motorbikes, caravans, boats, superannuation, shares and other financial products, pets, furniture, jewelry, and cash. In property matters, we also consider the debts that the parties have. So we're looking at mortgages, personal loans, buy now, pay later debts, car loans and leases, credit card debts, unpaid taxes, household bills. So the law doesn't tell people what assets they get in a property settlement. Instead, the law provides a process for determining each party's entitlements. The first step in this process is to identify and value the property of the relationship. The second step is to assess the contributions of the parties. This includes both financial and non-financial contributions, and you're looking at contributions at the start of the relationship, during the relationship, and following separation. The third step in the process is adjusting for the future needs of the parties. So here we're looking at who has the care of the children. We're also considering things like whether one party has significant medical expenses that would require an adjustment in their favour. The final step in the process is taking a step back and determining whether the division of property is just and equitable. This process is the same regardless of whether the parties were married or in a de facto relationship. To complete the first step of the process, identifying and valuing the property, both parties have a duty to provide full and frank financial disclosure of all documents and information that shows their direct and indirect financial circumstances. And the duty covers all assets, debts, and financial resources that each party has an interest in. Once the parties' entitlements have been determined, they must then decide how they're going to divide their property. So the process for determining or negotiating a property settlement, the first step is that the parties try and negotiate. If the parties are able to reach an agreement during their negotiations, they don't need to attempt dispute resolution and they don't need to go to court. They can keep their agreement informal. This often happens where the parties have only a small number of assets. They can also make a binding financial agreement. If their parties want their agreement to be made into court orders, they can apply for consent orders. Where the parties cannot reach an agreement, they must make a genuine effort to resolve their dispute before they can apply for property orders. This means that they must comply with the duty of financial disclosure. They must also attempt some form of dispute resolution, or also known as mediation. And finally, they must write to the other party, setting out their position and exploring options to resolve their dispute. In limited circumstances, the parties may exempt from taking these steps. The exemptions that apply to property settlements are similar to those in parenting matters. If a person thinks that they are exempt from participating in dispute resolution or any of these other pre-action procedures, they should get legal advice. It's very important that they do this because if they are not exempt, then they must comply with these procedures. If after complying with these procedures, the parties still can't negotiate a property settlement between themselves, then they can apply to the Federal Circuit and Family Court of Australia for property orders. Before the parties finalise any agreement, be it informal or a binding financial agreement, or apply for court orders, consent orders or property orders, it is important that they receive legal advice. Okay, so in addition to property, we'll also cover spousal maintenance. So spousal maintenance is financial support paid by one party to another party who cannot adequately support themselves. Spousal maintenance is a separate process to property. However, the court can deal with both property and maintenance at the same time. A person may be able to receive maintenance where they cannot meet their own reasonable expenses from their personal income or assets, for the following reasons. They are caring for a child of the relationship. They are unable to work due to their health, disability, or age. They no longer have the necessary skills to gain employment, or they cannot support themselves for another good reason. Where a person may be eligible under those criteria, the other person must be able to pay them. If a person cannot pay maintenance, then an order cannot be made. So there are time limits for applying for both property and maintenance orders, and they are the same. For married couples, there is 1 year from the date the divorce order comes into effect. So this is 1 month and 1 day after the divorce hearing, and this will be set out on the divorce orders. For de facto couples, they have 2 years from the date of separation.
Sorry, it's at this point that we want to talk about safety. So a relationship breakdown is consistently rated as one of life's most stressful events. So the safety of all parties during this time, including children, is paramount. So safety risks can arise or increase at different times. So this might be when the relationship ends. It might be when parenting arrangements change. It can be when court orders are applied for, whether that's parenting orders, financial orders, or it could be a divorce application is filed with the court. It can also be when one of the parties starts a new relationship. So if a person has immediate safety concerns for themselves or for their children, they should contact the police. The police can apply for apprehended domestic violence orders, or AVOs, if they suspect or believe that a domestic violence offence has been committed or is likely to be committed. So AVOs, again, will be addressed in more detail in a later webinar. So the Federal Circuit and Family Court of Australia also takes family and domestic violence seriously, and there are provisions to ensure the safety of all parties attending court. It is important for people to get legal advice if they have safety concerns for themselves or their children.
Okay, so when it comes to dealing with family law matters, there's no right or wrong order. Each family situation is different and each family will have different priorities. So it can be helpful for a family to plan for how and when to address each of the different issues that they have to deal with. Safety is always a top priority, and addressing safety concerns as they arise, of course, is paramount. If the parties have children, it is important that parenting arrangements are put in place as soon as possible. If the parties are going to apply for a child support assessment, they should also do this as soon as possible. If they wait too long, this may affect what Centrelink benefits they are entitled to. The parties will also need to deal with property and maintenance. Usually you can deal with divorce last, but as I said, it does depend on the circumstances of the parties. Okay, and now here are some helpful resources that you can provide to your clients. So I'll just take you through them very quickly. Amica is an online tool that assists separated couples to reach an agreement about parenting matters and simple property matters. We also have some resources on the Attorney General's Department website. So there are 3 comprehensive guides that we've listed here: parenting orders, a guide on property settlements, and then separating with debt. There's also the Best for Kids website, which has resources for both parents and kids about when families separate. There is the Family Relationships Online website, which has a range of information and services to assist separated families. There is the Family Violence Law Help website. It is the National Domestic and Family Violence Help website. The Federal Circuit and Family Court of Australia website has a comprehensive guide to family law matters. It includes detailed information about the different areas of family law, and it includes information about fees and forms and the process, and also the link to the Commonwealth Courts portal if people are accessing that for their matter. On the Representing Yourself section of the LawAccess website, we have a divorce topic, which is a comprehensive guide to applying for a divorce or responding to an application for a divorce. And then we also have Services Australia, which has information for separated parents about child support and Centrelink payments. And then we have our Legal Aid New South Wales brochures. So we have 5 fact sheets covering divorce that take you through 5 different steps in the divorce process. And then we also have the What Happens When We Split Up brochure that is designed for Aboriginal clients.
So where you have clients that are approaching you and maybe needing some family law advice, these are some options for you to make referrals for your client. So LawAccess, which provides legal information and also in some circumstances legal advice, is a free service for clients, and they can contact Monday through to Friday, 9 to 5. Legal Aid New South Wales also has a range of different services that clients can be referred to. So there are local legal aid offices scattered throughout New South Wales. The Early Intervention Unit is also a statewide service of legal aid. There is the Domestic Violence Unit, again within Legal Aid, which is a statewide service, and the Child Support Service, which provides specific advice for both payee and payer parents with child support issues. There are also community legal centres throughout New South Wales where clients can be referred to again for free legal advice and some minor assistance. In some circumstances as well, it may be appropriate for clients to reach out to private lawyers who can provide them with legal advice and representation in their matter. So we do have other upcoming webinars in this series. The next one will be parenting after separation, so spending a lot more time looking at the different issues that come up to do with parents and their children. This webinar is planned for the 26th of April, and there'll be links on how to register in the resources that are sent out to you at the end.
Thank you, everyone. We've managed to work through that in less time than what we had anticipated. So there's plenty of time for questions. And yes, I apologise. I neglected to upload the slides as a handout, but I will ensure that they're sent to you in an email following the end of this webinar, so you can read them again at your leisure. Does anyone else have any other questions apart from getting access to the resource? So far, we haven't got any. I think the information was clear enough so that people feel they've understood. One thing that we are interested in longer term are issues that your clients raise with you related to family law. That will help us with the planning of the rest of the series that we're planning for to put in webinar form. There's a comment here, I'm unclear about what steps the court takes to address domestic violence. Is one of you able to speak to that?
Yep, so I'm happy to cover that. So there's a range of different ways in which the Federal Circuit and Family Court of Australia will address domestic violence. That people can contact the court and ask for, if they've got safety concerns in attending, can raise those with the court to ensure that they're safe whilst at court. That might include meeting with sheriff officers at the court. It can also include ensuring that they've got a safe place, but also alerting the court that there are safety concerns. There are provisions as well where there have been findings of domestic violence that the domestic violence perpetrator is not allowed to cross-examine directly the victim of that violence in those proceedings, whether that's parenting or property proceedings. Also within the legislation, so within the Family Law Act, family and domestic violence is a factor that is considered when the court's making decisions about what's in the best interests of children and how the safety of children would be affected when making those sorts of orders. So there's a range of provisions. I think it is important, if you're speaking with a client who does have safety concerns, that that's something that they're bringing to the court's attention early on, but also raising with the solicitor that's assisting them so that plans can be put in place to ensure that person's safety throughout court proceedings.
Okay, the next question that we have is, do they have free legal support regarding property dividing for each party?
So it's always going to depend. So legal aid has, people are able to contact those free legal services that we mentioned today. So LawAccess, the different sort of sections within legal aid and some community legal centres. And in most cases, people would be able to access free, at least one-off legal advice to be able to give them some legal assistance in that matter. Depending on the circumstances, it will then be, is that person eligible for a grant of legal aid? So legal aid has policies around who is eligible. So the means test, and there's also merit testing available on the legal aid website. And that's something that legal aid lawyers are readily able to discuss with people. It will also depend on how the matter's going to be resolved. So there is mediation that's offered by legal aid in property settlements, and Again, depending on how that mediation takes place or which program that mediation will go through, sometimes both parties are eligible for legal aid if they meet that means test. Sometimes one party is. There are some circumstances, though, where beyond that initial free legal advice, people may need to be seeking private legal representation, and that could be based on the nature of the property pool, so how much it is or what type of property it is. But again, it's always about starting with LawAccess or legal aid to get that initial advice, and for that person to then, have the options made available to them based on their circumstances.
Thank you, Emma. The next question is that really a comment that the worker has experienced difficulties in contacting LawAccess and Women's Legal Services. Do we have any suggestions?
Michelle, do you want to take that one?
Yeah, so I guess it depends on what difficulties have been raised. Yeah, I mean, if the phone lines do get busy, so I guess if you can't get through, maybe try contacting at a different time. Or yeah, with the Women's Legal Service, you might be able to send an email. But yeah, I think it depends on what the actual difficulty is.
Michelle, LawAccess now has an online chat function as well, haven't they?
Yes, we do. So on the website, there is a web chat that's available where people can get information only. And then if they need further assistance, they'll be directed to contact LawAccess via our phone number to speak with someone to get further information or to also get some legal advice.
The next question I can address, it's if I can't attend the next webinar, is there any chance of accessing it afterwards? And the answer is yes. All our webinars are recorded and they're usually uploaded to Legal Aid's YouTube channel within a day or so after the webinar. So if you go to the Legal Aid website, there's a YouTube icon on the main website. And if you click on that, that will take you to Legal Aid's YouTube channel, and you can search there for all our recorded webinars. So if you're unable to attend when we're broadcasting live, then you can certainly access the information afterwards. And if you register for the webinar, even if you're unable to attend, we can send the resources to you after the webinar has occurred. And if you have any questions that arise, feel free to contact using the CLE email that's contained in the registration emails, and we will pass those questions through to the appropriate team within LawAccess and Legal Aid. The next question is, what is the general length of time for a family law court case?
Excellent question. And my response is always, how long is a piece of string? So there is no, there's no general time frame. It is common knowledge that the family courts are an extremely busy jurisdiction. So it can, and again, it depends on each of the matters. So the longer parents are unable to reach an agreement, the longer that matter will continue. So there is no general time limit. Yes, people talk about 2 years, 3 years, 4 years, 5 years, but those are often extreme cases. What I can say is that the majority of matters or parenting matters, even property matters that go to court, will actually resolve in people reaching an agreement. It might be after ongoing proceedings and intervention by the court, but it's not after a hearing. So it is important that people are getting legal advice so that they can get or they can make informed decisions early on in that process to be able to I suppose manage costs or manage time, manage stress as well. But there is no general time frame.
Thanks, Emma. The next question is, to what extent are the children involved in the court proceedings?
Michelle, do you want to cover
Yeah, so it depends. The court can take into account the views of a child. Obviously, it will depend on the age of the child and their maturity. What happens is in parenting matters, children, if their views are going to be represented, can have an independent children's lawyer to represent them. And then that person can then represent the child at court and help assist those views. There are also processes throughout parenting matters where you can have child inclusive conferences and family reports done where the views of the child can be taken into account. So it's not that children are really attending court to give evidence, but there are other processes. And as I said, the court will take the views of a child into account, factoring in their age and their maturity and the other relevant factors.
Thank you, Michelle. The next question is a person asking for an update on coercive control.
That might be one that we take on notice. So I know one of the later webinar series is covering domestic violence and apprehended violence orders, and it may be that that's something that we can cover then. So if we take that on notice, if the person asking that question has specific questions about coercive control, maybe they can be sent through to the CLE branch, and it's something that we can answer specifically via a different channel.
Yeah, thank you. The next question is, are there any additional issues to consider in regard to step parents and blended families?
So when we're talking about parenting decisions, it's parents, so the biological parents of children who have parental responsibility for children. So primarily when there are disputes in place about children, it's those parents. However, the law does also recognise that there are other people significant to the care, welfare and development of a child who can apply for parenting orders, and the court can consider making orders with respect to those people where it's in the best interests of children. So for example, that may cover a step parent, or it could include, so when a child spends time with a step parent, if that was going to be in the best interests of the child, and that may take into account stepchildren. With regards to divorce proceedings, so one of the requirements for the court to grant a divorce is that proper arrangements have been put in place for children under the age of 18, and that can include stepchildren if they are under 18. So the court does have quite a broad perspective in that case. But primarily when we're talking about parenting, it's the parents, the direct parents of that child, but there is scope and provision for other people to apply for orders or for orders to be made with regards to those children.
Okay, the next question is, a client that has fled a domestic violence situation with her young children has raised concerns that the ex is manipulating the mediation process. What can be done about this?
Okay, so mediators, just so everyone's aware, they are independent, so they don't represent either party. If someone has concerns that the process isn't being run fairly, or they have safety concerns, they should really try and get some legal advice about the process. I guess it depends on what service they're going through. So mediation can be run through a family dispute resolution centre, where it is essentially the two parties and a mediator. But legal aid also have their own mediation service or family dispute resolution they can run. So I guess the issue perhaps won't come up as much in those legal aid sessions. But if someone is concerned about that process and it being unfair, them not being able to negotiate because of domestic violence or other issues, they definitely need to get some legal advice, and they may need to get some assistance about how to negotiate and deal with that matter going forward. If there is serious issues there in terms of unfairness between the parties with domestic violence, mediation may not be appropriate, and for that, people would need legal advice.
Thanks, Michelle. They also use the shuttle mediation process as well, don't they, to assist parties who don't feel safe in that process? Is that right?
Yeah, so there's a range of, because of COVID, a lot of mediations have been happening by telephone. I guess going forward, what kind of form they will take will depend on the services. But yeah, if people have concerns about their safety, they can, do the shuttle service. They can, if the service will allow it, they can be in the same room. It would be depending on the circumstances, and again, it might be appropriate for someone to get legal advice about the best way to handle that situation.
Thank you. The next question is, I'm wondering about advising a woman who is in a relationship with safety concerns. She is considering leaving. Currently, the partner has the mortgage and is the sole interest on the house title. She pays for all other expenses. Does this place her at a financial disadvantage at property settlement?
Often when we talked about safety, safety is also about planning and people getting early legal advice so that their interests are maintained, but also that their safety, physical safety, as well as financial safeties are maintained. I suppose it's difficult to provide specific advice in that situation, but I would say, reach out to one of the services that we've suggested today for that client to be getting legal advice. Michelle talked about, identifying all of the assets that are held by the parties, and that might be that they're owned jointly, it might be that they're held separately, and that requirement of disclosures there to ensure that there's a clear understanding of what's in the asset pool at the time property is divided. And it may be that through that process, titles changed in a property or there's money moved between accounts. It's going to depend on each individual circumstance as to how that matter's dealt with. But it is a really good opportunity for your client to be getting some legal advice to ensure that their interests are protected in the long term.
Thank you. The next question is, I support a lot of male clients whose partners withhold their children from them. Are you able to briefly explain what options are available to them, whether they have parenting orders, but also if they don't? Ex-partners, whose ex-partners withhold their children from them.
Yeah, so they're really key times for someone to get legal advice, and this is where those when I was talking about parenting disputes, and that can be because one person isn't letting the other person spend time with the children for a range of different reasons, and reaching out, getting some legal advice, and then if there's still no agreement that can be reached, maybe that's when mediation needs to take place. So the goal with parenting is to try and resolve disputes early, and also, if possible, to keep it informal. That often works for a lot of families, for those arrangements to be informal. So parents being able to reach an agreement, sometimes they need the help of lawyers to do that. Sometimes they need the help of mediation services to be able to have conversations and to focus on the needs of the children. But if that doesn't work, then that's why the court is there, to be able to make orders that are legally enforceable, that parties have a legal obligation to comply with, and that contravention proceedings can be commenced if parties aren't complying with those orders, because those orders are made in the best interests of children, for children to spend time with both of their parents, for children to be able to be safe, regardless of the relationship that their parents are in or are no longer in. So often it's about getting that help early, not leaving it years or months or years down the track and that relationship further deteriorating. But there definitely are services for mothers, for fathers, regardless, because the interests of the children are there to be served.
Thank you. I've just realised that the question about a client who's fled DV and raised a concern that the ex was manipulating the mediation process, there was a clarification to that question that I missed. The question is, what is your advice about how to respond to her allegation? Just wondering if you might add anything else with that clarification.
Well, if she this individual feels like the mediation has been manipulated, I think that's a situation to get legal advice. As I said, mediators are meant to be independent, so they should be trying to, I guess, ensure that that doesn't occur. If there are serious concerns, if I mean, it's going to affect ultimately whether or not an agreement can be reached, it'd be worthwhile getting legal advice about whether or not the mediation should occur, or trying to get some assistance to counteract that what that person feels is a manipulation. Maybe that individual just needs the advice to give them the confidence that they can go in to mediation, so that they can handle the mediation a bit better if they feel like they want that. Alternatively, they may, mediation may not be appropriate and they may need that advice.
Thanks, Michelle. There's a comment here. I find time again that the court insists on children having contact with an abusive parent. I don't know if you have anything to say in response to that comment.
I mean, I think, each individual case, if you've got concerns about a specific client that's involved in proceedings, making sure that that person has access to legal advice to ensure that, they're represented, their views are being put forward, so that, what they want to be seeing in the best interest of their children is happening.
The next question is, how do the courts manage those clients that self-represent in court?
I mean, the family law jurisdiction is often one where people are self-representing. The courts, people can't be forced to have legal representation, and sometimes people don't have a choice other than to self-represent. So judges are not in a position where they can provide legal advice to those clients. They may provide them with directions on things that they need to follow up on, or services that they can access, but it is a challenging jurisdiction. It's why services like LawAccess, the Early Intervention Unit, which has a duty lawyer service attached to it, is there to try and provide some assistance where we can in those matters. But it is challenging. There are resources around for people who are self-represented, but it's there's no specific answer that we can give other than it's common. The courts do try, there are resources, but it is challenging for those people.
Next question is, do you have advice for structuring family finances that aren't prejudicial to women's interests?
That might be a situation that people need to get, it depends on the circumstances. And it's probably something that people want to get advice on at the commencement of a relationship, and that's where you're looking at things like binding financial agreements. It is something that people would need to get advice on, I guess, before. You can make a binding financial agreement before, during, or after a relationship. So that might actually be a step that people take rather than at separation, but beforehand, if they do have those concerns.
Next question, is there a wait time to access legal aid, or can people be assisted as soon as they make contact?
It really depends on the nature of what the issue is. So if they have an urgent matter, we will always try and help them as soon as possible. So within LawAccess, customers can be warm transferred through to lawyers if they have an extremely urgent matter, and if necessary, we can warm transfer them through to legal aid, the various divisions within legal aid. Customers can also be booked. So it depends, I guess, if someone needs advice at a specific time for, say, example, a safety reason, we can book them in at a specific time. But generally, we'll try and get back to people sort of within 2 weeks, of course, prioritising those people with the most urgent matter.
And most legal aid services will have bookings available, so people will be given a time generally within 2 weeks, and again, assessing that urgency. If someone is applying for a grant of legal aid, that can take longer to process that application, sometimes up to a couple of weeks. But urgent legal advice can generally be provided to someone relatively quickly.
There's a question about the eligibility criteria for legal aid.
Yeah, so again, what might be useful is to have a look at the Legal Aid website, where there is information there. There's an A to Z guide to policies. It talks about the different types of eligibility, also the different tests that people may need to satisfy to be eligible for different types of legal matters. So a parenting matter might be quite different to a property matter. Again, someone who's eligible for mediation, there's going to be different requirements for that as opposed to representation. So the Legal Aid website has a lot of information there about eligibility, but again, it might also be getting legal advice about whether that person's eligible or not.
We also have a question about what is the difference for divorce when a child is below 18 years old or reaches 18 years old?
Ultimately, it comes back to the process and also the criteria. So if the children are over 18, then the parties don't have to make appropriate arrangements for the care of that child because technically they're no longer a child. If a child is under 18, they have to have those care arrangements in place, and then they may need to attend the hearing. So it comes back to how they apply for a divorce, whether it's a joint application or a sole application, and it will affect their attendance at court and whether or not they're eligible actually for the court to make a divorce order.
Thanks, Michelle. And the final question is a party eligible for spousal maintenance if they are not the party who will have parental responsibility or primary custody?
So you don't have to have the care of a child. We listed several different factors, so you don't have to satisfy all of those criteria. The test is essentially a two-step process, as we set out. So the first step is that you must not be able to meet your own reasonable expenses for one of those reasons. And then the second step is that the person that you're asking to pay maintenance must be able to pay. So it's not necessary that you have the care of the child, but just that you have that reasonable excuse or reason for not being able to meet your own expenses.
And so that's the end of the questions that we currently have. I just wanted to thank both Michelle and Emma for speaking to the webinar today and answering all those questions, and thank everyone for joining us in the webinar today. I will make sure that the handout goes out in the email that follows this webinar. And please feel free to send any other questions that you may have, and we can forward those to Emma and Michelle. And Emma and Michelle, we're getting lots of thank yous, people saying they found the session very helpful and that it's a great overview. So that's really great positive feedback.
Thank you.
Thanks everyone for attending, and please join us for the next webinar in the series that's currently scheduled for the 26th of April.